live at 5. Tonight we have a very special show in store for you. We'll be discussing the conduct of resale price maintenance. Tonight we have expert A.B. Reid here to discuss his topic with reference to ACCC and Dermalogica and ACCC and Jurlique. We also have barrister Breen here to discuss his topic by discussing TPC and Penfolds wines and TPC and Sony. So Amy, can you tell me exactly what is resale price maintenance?
Certainly. So resale price maintenance, or RPM, is defined in Section 96 of the Competition and Consumer Act 2010. It essentially includes any act a supplier engages in which has the effect of mandating a price minimum. Now, subsection 96(3) encompasses a very broad range of activities that are prohibited by RPM. Now, this includes withholding the supply of goods or entering into an agreement or offering to enter into an agreement that has the effect of regulating a price minimum.
Right, okay. So what exactly needs to be proved to hold that a business or a supplier is engaged in RPM?
Sure. Now, this is an offence that is prohibited per se. Now, that means that it's not necessary for the applicant to prove that the respondent's actions have a significant lessening of competition effect. Rather, it's sufficient for the applicant merely to prove that the respondent engaged in the acts that constituted RPM. It is important to note, though, this area of law may face changes in the coming year due to the release of the Harper report earlier this year.
Yeah, of course. So, what's the main incentive for courts to impose penalties?
That's a really great question, Bree. As one of the incentives for the courts is to ensure deterrence. Both the cases of Jurlique and Dermalogica centre on this issue. Thus, the damages have to be substantial enough to outweigh any potential benefits of engaging in RPM. Now, in Jurlique, the total amount the respondent companies and the director were obliged to pay amounted to $3.4 million.
Wow, that's quite hefty. So, to be clear, what are the problems with RPM and are there any benefits?
Now, in Jurlique, the court discussed the implications of RPM in the context of prestige goods and found that sometimes RPM may not be particularly anti-competitive or damaging to the consumers. However, His Honour also did note that he was bound by legislation and it's clearly prohibited under the Competition and Consumer Act. On a more general level, however, conduct that constitutes RPM has the effect of diminishing competition in the market and removes competitive pricing. As a consequence, it's usually the consumers who are adversely affected.
So what will the court consider as relevant when determining the penalty?
Okay, so this was of particular relevance in the case of Dermalogica, as the court considered deterrence as well as the circumstances surrounding the relevant conduct and who was responsible for the offending conduct. So as seen in Jurlique, the penalty will be higher if the conduct was instigated at the level of senior management. The market position of the contravenor, their cooperation with the Commission and acknowledgement of the liability is also relevant to calculating damages.
Yeah, of course. Okay, so just heard from Amy who's discussed penalties. So, Greg, can you discuss the elements of resale price maintenance?
Well, certainly, Bree. As Amy previously said, RPM covers a broad range of activities. Between the two cases of Penfolds and Sony, the Commission alleges the respondent's conduct could have fallen into one of 5 separate characterisations of retail price maintenance. Naturally, each definition of RPM entails different elements, but one element that is consistent in all forms of RPM is the term less than price specified. In the Penfolds and Sony cases, the Federal Court held that a specified price need not be an exact figure. It can be established with simply a figure, a range of prices, or otherwise by mere approximation. Furthermore, in Sony, the court held that there was no requirement for rigid insistence upon precise adherence to a specified price.
You say mere approximation. What exactly do you mean by that?
You see, Bree, where a supplier limits the range of prices which may be charged by a retailer, this may be treated as a mere approximation. A supplier may be found guilty of RPM if they only tolerate a specific variance between their prices and the retailers. So, for example, in Penfolds, the Commission found that the supplier tolerated a specific price between the prices that could be charged by the retailer and those charged by Penfolds to the order of 1.4%. This level of tolerance was found to constitute an attempt by Penfolds to prevent the retailer from selling products at less than a price specified.
Right, so just lastly, who bears the onus of proving that a supplier is engaged in this conduct?
Well, Bree, the party who brings the case must prove these elements on the balance of probabilities. In Penfolds, the court held that the onus was on the Commission to prove characterisation of any variance tolerated by Penfolds as a limit of the range of prices allowed, which may be treated as approximating a specified price. Also, this must be supported by evidence and a consideration of the relevant market the parties are operating within.
Okay, thank you so much, Greg and Amy, for your time. I'll see you guys next week.
Thanks, Breanna.